I don't know. After hearing him calm and talking about the tether story, it's probable.
Let's go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
Flirting with the judge in front of my dad.
What's going on? This is Colin. How's everyone doing? Happy Wednesday. Hope everyone's good. Got a huge variety of random court clips for you today. Off with my new favorite game, Are They Going to Jail? I can't remember if I have one or two. I think it might be just one. I think it's just one from Judge Washington. In-person hearing, Are They Going to Jail? Could be. I'm not going to spoil it. And then we have some DiSanto and... Oh, we finish up with McConico. We got, like I said, wide range. But the best clip is she naked? We're going to find that out. Well, we don't actually find it out, but I want to know what you guys think. Because it's weird, and I'll give you my opinion on it before the clip starts. All right, before we get into it, you already know what to do. Like and subscribe, do your jump kick backflips. And as always, my link tree is in the description. If you'd like to donate, please and thank you. It helps me out a lot. I do spend a lot of time on these videos and watching court every day. Speaking of that, Greg is working hard to be the #1 supporter on the channel. He's getting close to Phil and Mimi. I don't know. I need to go add up what he's donated, but he's getting close. Just letting you guys know that. I'm playing. All right, let's go.
Should we stand or sit?
For now, you should stand. Please place your pencil on record.
Morning, who would also speaking with on behalf of Darian Randolph, who's standing to my right.
Thank you. Please state your name, Mr. Randolph.
My name is Darian Randolph.
Thank you. All right, you were arraigned on a bond violation back on November the 6th, sir. You're here in person because you requested to have a hearing on this bond violation. Have you had an opportunity to talk to your client? Are you still requesting a hearing today?
That's all correct what he's saying. We're here for bond violation hearing. And before we proceed with any of this, I would ask to approach with Ms. McDuffie.
That's not really possible in this particular environment.
Well, then I do have to say it out on the record. After speaking with Mr. Randolph this morning and on previous occasions, we as his counsel are concerned about his competency. And we would ask the court to make a referral for him to be evaluated. I discussed with Mr. Randolph this morning. I had particular reasons to relay that I would, but you can't have a bench conference and I got that.
Okay, thank you. Ms. McDuffie, he wants to refer his client for competency.
Your Honor, so this was a bit unexpected. Unfortunately, I would need to discuss this further with counsel and Your Honor, and I know that a bench conference is not possible because I'm almost inclined to object to the request, but I want to hear more from counsel about it. And since this is the first time I'm hearing about that request, I'm a little bit at a loss as to how to respond to that.
Well, I can tell you the bottom line is if his counsel has concerns about his competency, neither you nor I are actually dealing with him on an intimate basis. So he's the one who makes that decision. And if he has concerns about his client's competency, I'm generally going to make that referral. Would have to be something very strong for you to convince me that he doesn't have the ability to make that determination.
I understand that, Your Honor. It's literally the fact that we have never discussed this whatsoever. So I'm not offering that I would be attempting to convince the court that it's not warranted. I had no reason to anticipate that this could even come up at all, and I don't have any indication of there being any concerns on this case or the previous case where he was represented by counsel. So given the way that things are progressing and what I've seen from Mr. Randolph and discussed with counsel, my concern, I can't even speak, I can't address it because we literally haven't discussed it. But I guess what I would ask the court is, regardless of what happens with that order, does that also put the case as well as his bond violation in limbo regarding the testing issues?
It does. Anytime
It does.
anyone is not competent or there's a concern regarding their competency, it obviously places everything else in limbo because we cannot make decisions about an individual who may or may not be competent.
All right, I forgot which hearing this was. Clearly, this isn't is this guy going to jail or not? He should be. I think that Judge Washington explains what his violations are. But this is my question to you. This is why I put this in here. Is this a stall tactic? I feel like it is. He's gone through multiple hearings. Now we're on a violation hearing, and his attorney is just now saying that he has competency issues, while the defendant just stands there. And the problem with competency tests right now, I hear it in every single court, they prioritize the people in custody over the people out of custody. So if you're not in jail, it could take 6 months for a competency test. And even the attorney does not sound happy about saying this. Now, I know the attorney can't do that. They would get sanctioned if they put that up there and said, oh, I don't think he's competent, just to stall. But I mean, what do you guys think? What do you guys think? Just listen to the voice of the attorney. He's not happy about doing this. At least I don't think he is.
So he's still,
That's right.
I guess I should clarify. He's still ordered to test, but we're just postponing the hearing on the violation.
Correct.
Okay.
That
thank
is. So your client still needs to test. And I will adjourn this matter for the competency hearing. Do you have an order prepared today?
I do not have an order prepared. It came out of discussion this morning with Mr.
I see. And you will provide this court with a copy of that order by the end of the day? All right. Just so that I can track this matter, I'm going to schedule it over to January 8th, 2024 at 10 a.m. And if we don't have the order, then of course I will not be happy about that. But if we don't have, but if the order is in, I don't believe that we will have an opinion regarding that, but hopefully we will at least have a court an interview date scheduled. And they can do those now via teleconference. So please see if you can schedule that via teleconference so that we can know whether or not he has that already scheduled.
And
Very
Joanna,
good.
could I just
Yes.
also advise counsel that there is currently a 5 to 6 month waiting period for any orders for folks that are not in custody. So he actually needs to proactively reach out to the forensic center and request that a Zoom exam be set up. Because they won't tell you anything and our date will come and go. And then if you reach out and ask about it, they'll tell you that. So just so you know up front, so you can get that set up, we might be able to get it done by the next date if you approach them.
Thank you. Yes, we've worked with the Forensic Center before, and I've contacted there to find out the process. Yeah.
So please do that. Please schedule that for the Zoom teleconference on, unless there's some specific reason why, and that would require that we have a conference regarding that. Okay?
Very good.
So I'll see you back here on January 8th. That'll be via Zoom, so that we can have any conferences we need to have regarding his competency concerns.
Yes, and I will submit the order today.
All right, thank you.
Thank you very much.
All right, what do I have next? I think next is the thumbnail clip.
So he was,
I don't think that there is an issue with any.
Why
of
am I
the facts that-
rewinding?
where are you with this matter, sir? Case number 20-00510.
All right, yeah. I just didn't delete the end. Sorry about that. Yeah, that's strange to me. Where he's on a violation hearing, so he's been, sentenced, and he's on probation, is what I think. If I remember right, that's what is going on right now. So it's a probation violation hearing where he had to show up in person, and now they're saying he's incompetent. Maybe that was the sentencing. That was supposed to be the sentencing. I don't know. I don't remember. That was from, I think that was from, I don't know if that was Monday. I don't know. Sorry, that was supposed to be my clip from last night, and I was way more prepared last night than I am today. And I already deleted my notes because I got ready for today. Not really a good thing to do. But that doesn't bode well with me. I think the attorney is playing games, and I don't like that. All right. I think the next clip is the potential naked woman in court. The case itself is boring. And I'm going to spoil it a little bit. The judge never calls her out on potentially being naked. Now, I will say, as a YouTuber, I was staring to see if anything popped up and I needed to cover anything. Also, as a guy, I was also staring to see if if anything popped up and I had to cover something. But you guys tell me what you think. It's only about a 5-minute clip. And yeah, let me know if you think she's actually wearing clothes or not. Please let me know. Yep, it's it.
Yes, ma'am, we're ready.
Ms. Williams, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yeah.
All right, you can put your hand down. So, Ms. Williams, you're before the court on 2021 CR 03929. You're represented by Attorney Leon Hicks, and he's here with you. You're entering a plea to affray. Mr. Hicks, what does your client plead to the offense of affray?
We're pleading guilty, Your Honor.
All right. By entering a plea of guilty, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Ms. Williams, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On October the 8th of 2020, an officer was dispatched to 415 Sandalwood Drive in Morrow, Georgia, where the incident did occur in Clayton County. The officer was responding in reference to a domestic disturbance. Upon the officer's arrival, he did meet with the defendant, Miss Brianna Williams, as well as Mr. Devontae Ashley. They both advised that they had been in a physical altercation. They were in a relationship together and had an argument that turned physical. The officer then, after speaking with both of them, took them both into custody. The state is recommending for Miss Williams 12 months to serve 5 days. Credit for the time that she has served, the balance to be suspended, pending no new violations of the law and no contact with the co-defendant, Mr. Devontae, Devante Ashley, Ashley.
All right, Mr. Hicks.
Yes, ma'am. Essentially, that is correct. She got a ride with the father of her child and his new girlfriend, which I thought was quite remarkable. And then they got into an altercation. She was sitting in the front seat, he was in the back, and he grabbed her by the hair and got out, ran towards where she'd last seen the police. This is why we pled not guilty in the beginning, but I think this is an outcome that is good for her.
All right. So, Ms. Williams, so Mr. Hicks has indicated that this gentleman is the father of your child. I'm not sure if he has a child and he's considered the legal father of the child, not the biological father, but if he's considered the legal father of the child. But what I would advise is if you want any contact with him for the purpose of your child, go through the superior court, go through the legitimation and visitation and custody process so that you can get everything legalized. And that way you will have a schedule from a superior court judge that tells you what kind of contact you can have with him on behalf of your child. Now, that does not change any effort to pursue child support or anything like that. Your child is entitled to that. But I would say that if you want to have any contact with him regarding the child, go through the Superior Court, and that way you won't be violating your sentencing conditions, and you can have the contact that you have with him managed by the court. Listen, when I like Mr. Hicks said, it's surprising that you and the father and the new girlfriend would be in the same car together. It's not, I don't say that's a bad thing necessarily if y'all are trying to normalize the situation where you have each moved on. But if it's not that situation, and if both of y'all aren't mature enough to handle that kind of contact, then go through the courts until such time as y'all do have the ability to say, hey, he's moved on, I've moved on, and we can do this for the sake of our child because we have to co-parent. Okay? That's a very mature attitude at that point.
Yeah.
Okay. All right. So, ma'am, I'm going to send you to 12 months to serve 5 days credit for time served, balance suspended, as long as you have no new violations and no contact with Devontae Ashley. And at this time, ma'am, you're free to go. Okay.
All right. Thank you.
All right. Thank you. Thank you, Mr. Hicks.
Thank you, ma'am. Appreciate it.
All right. All right. May I have an announcement on Stokes, or is Miss
All right. Yeah. So what do you think? I saw the comment in the chat. Yeah, there's definitely, the lawyers were definitely looking at her like, what is she doing? The judge never brought it up. I don't know why. I do really like that judge. Maybe she was just trying to just get by it. Like, let's just finish this as fast as possible. I don't know. But yeah, let me know. What do you guys think? Did she have a top on? If she did, it still wasn't right for court. It wasn't appropriate for court. It doesn't matter. That was not appropriate. And like I said, she didn't get called out on it. All right. Next clip, I believe, is Judge DiSanto. Oh, this is a good one. This is a good one. If you haven't done it already, please like and subscribe. If I haven't said hi to you, I just saw Mimi. Mimi Praise just jumped in the chat. Hi, Mimi Praise. All right. Let's go.
Give me a line that there's Samantha Thomas, 231336. And
P36827 here on behalf of Samantha. That's not a title. Samantha.
oh, Samantha, that's right. There's not an M in there. Okay. And your name for the record.
Samantha Nicole Thomas.
All right. And
All right, let's play our is she going to jail on this person. We can play that game on this person because there's not a competency issue. So let's do it on her. I will say that her hearing was in 3 parts yesterday. She had to leave, come back, left, come back. I'm going to give you that little bit of information. But is she going to jail or not? I'm going to pause it after the first clip, or the first of the 3 clips, and then we'll see what you guys think.
the date scheduled for the pretrial as Ms. Thomas failed to appear for the pretrial September 12th.
I had COVID, ma'am. I did call up here.
No, I understand. Yep. And we know that we received notification and it was rescheduled.
Yes, I believe that's correct.
And counsel?
Yes.
As to the pretrial.
Yes, with respect to pretrial, we would like to get a look at the discovery materials as before for a short adjournment and the entry of a discovery order for that purpose.
The court will sign the discovery order. And counsel, you're back on December 19th at 10 a.m.
Yes.
All right, so December 19th at 10 a.m.
Thank you.
And ma'am, if you were to test today, what's in your system?
Weed. I haven't been doing anything else. I have smoked weed.
Do you have a prescription for marijuana?
No, ma'am.
Okay, well, do you recall this court's order on your at your arraignment not to use or possess any alcohol or drugs that are not prescribed?
If I get a prescription or
That wasn't my question.
No, I do apologize.
My question was, do you recall this court's order that you're not to possess or consume any alcohol or drugs without a prescription? You do. Yeah, you're using marijuana while on bond.
I haven't been using it all the time, but yes, I have.
Okay, and then when I asked you what you would test positive for, you,
I said,
you did. Like it was no big deal.
no, I'm not meaning that it's not a big deal. I mean, I'm not doing anything else. And
So if I have you tested right now in my probation department, nothing else is showing up in your system
no. But I will have weed in my system, man.
and nothing else.
No.
And when's the last time you used marijuana?
Probably like 5 years ago.
Okay. Council, we're going to recall this man. We're going to have Ms. Thomas tested right now.
That's it.
All right, thank you.
Probation department.
I'm going to have you have a seat here. I'm going to have a court officer escort you over there.
Okay.
Okay, we are recalling.
All right, first glimpse. What do we think? People are already saying jail. I mean, she's getting drug tested. We'll see. We will
On the
see.
matter of Samantha Thomas, 231336 A and B. Yeah, me too.
It's me.
I'm sorry. I know it's going to be your name all the time. I'm sorry. Can you say it again, please?
It's Nathan Thomas.
Okay. So, ma'am, you tested over probation because I had some concerns that you are under the influence of something.
I am prescribed Suboxone and Colin. And I do have the pill bottles. I'll bring them up for you and all that.
Okay, but did you not just indicate to the court that only marijuana would be in your system?
I wasn't really thinking, because it's been like in the moment, and I'm like frazzled in my head, I guess.
Perhaps that might be because you have cocaine in your system?
The cocaine should not be in my system.
No, and why not?
Because I haven't been doing cocaine. I've been actually doing pretty good.
Well, you just tested positive for cocaine.
I don't know how that's possible, and I swear, because I have been doing it. I've been really trying to not do anything like that. And yes, I did smoke weed. But that's all I have done. I haven't been doing no cocaine at all.
Oh, ma'am, you're positive for cocaine.
I can.
How'd you get here today?
My grandmother.
Your grandmother, where's your grandmother?
She's not in here. I have to go outside.
Yeah, you need to speak up.
I have to go outside.
She's outside.
She should be, yes.
Okay, and what kind of car did she drive you here today in?
Gray Escape. Or it's like a brand new one.
You did drive here.
No, I didn't drive.
I'll need a copy of this discovery order.
Yes, Your Honor.
Ma'am,
Yes, ma'am.
where do you work?
I work at 7-Eleven.
Which one?
The one over here on North Line One.
When DiSanto takes a drink of water, you know she's about to go off on a speech. She had to make sure her throat was hydrated.
I come back in court, I won't have weed in my system or anything.
I'm just wondering why I shouldn't revoke your bond right now, because you were ordered back in August not to possess or consume any alcohol or drugs that are not prescribed. And you have marijuana and cocaine.
I really don't know how the cocaine got in there. I swear, and I know you probably heard that like 100,000 times. But
Not quite, maybe only about 98,000.
right. But I can swear to you next time I come in the court that it'll be clear only what I'm prescribed. I mean, I don't know if you were able to test like levels or whatever, you'd be able to tell it that way. I mean, from today on, I won't.
You know, I have concerns that you're under the influence of something right now. Either you're taking, well, other than the cocaine and the marijuana, right? Which marijuana you used when, yesterday?
No, it's been a couple days since I've used marijuana, but I do take Suboxone and Klonopin, and it is prescribed, and I take it how I am supposed to take it. Actually, I take a little less because the way they prescribe it's too much. And I'm not driving, and I mean, I can assure you that next time I will not come in with anything in my system that I'm not supposed to have. I've been really good. I'm over 5 years clean off of heroin, which you've heard all about it, I'm sure. It's a very big feat in itself. So I'm trying to like better myself, and I am trying to shape up my life.
Yeah, it is. Yeah, I'm going to say this.
Yes. Just throwing
That
it
is
in.
commendable that you have been clean from heroin for 5 years.
But it's just gonna make me lose my job, and where's that gonna put me? You know what I'm saying? It's my
Tim, do not, listen,
No.
do not come in here trying to
No, I'm
make
not.
it appear as though I am going to be the reason you lose your job.
No, I'm not.
Your behavior and actions would be why you lose your job.
And I am assuring you that I will not be like that. I will not fail the drug tests. And I mean, that's all I can do. I really don't want to lose this job. I like this job. I like the people, you know, and it's convenient for me. It's right down the street from my house, and I help take care of my grandma. I mean, I'm not going to give you my whole sob story because you hear it all the time, but that's all I can do is, you know, just try to do my work.
Well, counsel, here's what I'm going to do. I'm going to revoke your client's bond. I'm going to move up the pretrial so that it won't be until December 19th. Can you be here on either the 5th or the 12th? I know that you're not scheduled.
You're talking about December, correct?
Yes.
You need to be here in person. I can,
If possible.
I love your moves.
what time would it be? Yeah, I'm open on the 5th of the month.
Okay. We can do 8:30.
Your Honor, the reason that we had requested an adjournment to the 19th was to obtain the discovery. I have no idea when we get the discovery. 5th.
Okay, how about the 12th?
I'll go and yell across all. I think you're getting another one this job.
I'm sorry, for
I'm
what?
also,
Sexual assault against your
I
officer.
designed you to class.
Well, first off, ma'am, those are not my officers.
I know. I'm just upset right now.
Well, it's fine. You're on the 12th.
Okay,
Necessary.
all right. Would 8:30 work better for your schedule, counsel?
Yes, sure.
For your calendar that day? Okay, thank you.
So I'm going back to you.
Yes, ma'am.
You're gonna put me back there. There is nothing I can do.
Ma'am, you tested positive for cocaine. you've used marijuana in violation of this court's bond.
I admitted it to you, you know, just not trying to be a liar, you know. I don't want to be that person. And I mean, there was multiple people in here that did the same thing. And they didn't get their bonds revoked.
Yeah, they also didn't test positive for cocaine today.
Well, I shouldn't have tested.
You have cocaine in your system.
But I shouldn't have tested positive for cocaine.
Well, but you did.
Can you guys test levels on me or something?
Sure, you want levels tested? All right, here's what I'm gonna do, counsel. I'm going to have your client go test right now. You're gonna go test right now.
Okay.
And then you're going to come right back here.
Yes, ma'am.
If you do not, a warrant will be issued for your arrest.
Okay. I will go and do what I have to do to show you that I haven't done it.
All right, and then you'll be coming right back. Well, all right, let's go off the record. Let me determine how we're going to do that, counsel. Let me just 1 moment off the record.
And we're gonna go to the part 3 now. If you guys have already voted, this is your chance to change your vote. Now, is she going to jail or is she going away? Did she just talk herself out of going to jail? Is what I want to know. Or is DiSanto just gonna be like, nah, you're going. Team bailiff all the way. Everyone that came in late, thank you so much for stopping by. If you haven't hit the like and subscribe button, please do so. It helps me out a lot. All right, let's go.
All right, and so counsel?
Counsel, excuse me, Your Honor, you had, during the matter, you were sending her for testing. We did in the interim, directed your court personnel to provide us with a look at the test stick that my client had used, for lack of a better word. Again, I am not an expert on such things. Neither is court personnel. There was an indication that brought up the issue of whether fentanyl was present. There's a mark. There's supposed to be a mark indicating, sort of intuitively it's backwards. There's a mark that indicates that a mark is good. There's a slight mark at fentanyl.
Very, very, very faint.
That's like a mark yet.
No, I understand.
She insists she has not had cocaine nor fentanyl in the recent past. And I don't know what the levels are, how long this will protect, or what the percentage reliability of such tests are. I didn't witness the test being done. My position is the test is invalid. She's willing to do more intensive testing. She's offered to do that. What is the?
I said I would go to Concentra, be back here at 8 a.m. in the morning to show you proof that I have not.
So I think there's doubt here. We'd ask the court to give the benefit of the doubt.
So here's what I'm going to do, counsel, because she's looking at jail time, and then I'm going to set this for a bond violation hearing. We're going to do it that way, so that if we need to, we can get the levels from the testing facility, and if there has to be additional testimony from the laboratory, then we can have that. So, but I'm not going very far out because of the nature of that. So at this point, let's put the pretrial back to December 19th, and then we're going to set the bond violation hearing for next week.
Thank you very much.
On Tuesday. In the meantime, ma'am.
Yes, ma'am.
You need to, you're testing every day.
It's fine. I'll test every day.
You're to test today.
Where can I,
You're going to stop at probation. They're going to give you that information.
does the test I did today, that don't count for today? You're not sending me out to go
You're going to go test today, and then we're going to get your levels as
Well,
well.
that's what I meant. Okay, I'll just wait for coach, I'm sorry.
8:30 a.m. Council, you can be here on the 5th at 8:30 a.m.
So the 12th will be off, correct?
Yes, nothing on the 12th. We're back to the 19th for the pretrial at this point.
All right.
And then at 8:30, and then the December 5th for the bond violation hearing, which is 1 week from today, 8:30.
All right, I got it.
Does the 5th work for you, Council?
Oh, I'm sorry, yes.
Okay, I just wanted to make sure, okay.
Thank you for stopping by, Joyous. I've got a lot of questions. I'm waiting for this to end, but I've got a lot of questions.
Yeah, do not leave without going to probation, and they will tell you where to test, and when to test, I believe the testing center reopens at 4 o'clock.
Okay. Thank you very much.
Have a good day.
Thank you.
How did she just talk herself out of that? Now I know Judge DiSanto just pushed it till next week, and she tested twice already. She tested, it came back positive for cocaine. Then she tested her levels, and then Judge DiSanto says she still has to test today. Hasn't she already tested twice? I don't understand what ordering another test today would do. I understand every day going forward till next Tuesday. I get that, but I don't understand why she would have to test again today. Maybe, because this happened between like 1 and 2 p.m. and she just said that the drug testing center opens again at 4. So maybe in case she uses something in between then, maybe that's why. I don't know. And Monkey, I think you're the one who said the case after that took the cake. I've got that one too, but I like to spread out my DiSanto. And I've got another one right now from our good friend Heidi from last week. Is that Heidi? I think it was Heidi. I've got her follow-up right now. And I've got a little clip for those who forgot who Heidi was, I added a little clip from my video from last week. All right, let's watch this.
Heidi Hoffman.
Okay, and I'm sorry, did you submit any proof of your diagnosis into the court today?
I can't today.
No, no. I'm asking if you already did that.
No, I have not yet.
Okay, well, your credibility with this court is not very good, considering last week you indicated that you had to leave and go to the hospital because you had COVID, but in fact, you ended up going to a different location, from my understanding, for some other reason.
That what?
You were here at court, and then you left. We are on the record in the matter of Heidi Hoffman, 231540.
We're on the record actually on 2 matters. That appears to be a formal hearing. The number you just called.
No, it's up for a hearing because it was a bond violation hearing. She pled not guilty. And so she entered into a plea on October 31st.
Yes, Your Honor.
Scheduled the sentencing for December 6th.
Yes, Your Honor.
There was a bond violation that was alleged, and it was set for November 15th.
Yes, Your Honor.
That's the day that she was here, claimed she had COVID, went to the doctor.
Yes,
Also allegedly told my staff members that she had to get to court or the doctor or something for her mom and son or something of that nature.
I agree.
So there are lots of different things that were said. Then there was apparently a doctor's note that she was here last week for, because we had adjourned it to November 22nd.
And Your Honor,
She apparently claims that she was still ordered to isolate, which typically, I haven't heard that since 2021. And in any event, claims she had a low-grade fever and all of that. Further, she finally sent over a doctor's note of some sort. And then we set it to today's date and for her to test on November 24th.
That's correct, John. And the whole scenario. She called me that morning, actually, that morning, saying, in fact, last week, that's why she was on Zoom.
I understand.
Right? We went all through that, I agree, Ron.
Yes.
But I think the case number, if you look on the docket, I know we have this matter scheduled for today, but the case number that you read.
Right, it says hearing.
Hearing.
Yes.
But
it's not a formal hearing. It just doesn't have all of her other cases on it, on the docket.
okay, Your Honor.
It says hearing, but it only showed for the no proof for insurance. It should have also showed for the other two matters, but it didn't. So it's just showing hearing. Otherwise, it would have probably showed as formal hearing. But I don't know. In any event,
Okay, I just want to
there's
make
not a formal hearing. It's a bond violation.
I understand that.
Yeah.
Okay, because, can I get my file? I just agree.
All right, while he's walking away, I'm going to do a quick recap. I know the clip that I showed, maybe everyone didn't see the whole hearing from last week. She claimed to have COVID, so she couldn't come to court even though she had to be there in person. Judge DiSanto asked for a medical record showing that she tested positive for COVID. This went back and forth for a couple of hours before she actually showed her a document that she went to a urgent care and was tested. Now Judge DiSanto never said she tested positive, but it showed proof that she went to the urgent care or the clinic to get tested. So she was let off the hook and told to drug test on the day after Thanksgiving, which was this past Friday, which is the day she just said. Whether or not she did that or not, I don't know. I don't remember if they say that in this. But then today was the time she was supposed to show up in person, and she didn't show up. That's the recap. Probably should have said that at the start of the video, but while he walked away, we can talk about that. Oh, who's headed to the hospital? Oh, Leanne. Yeah. Prayers for Leanne, everybody. I hope everything goes well. Also, Hayden, I saw your question earlier. Yes, that woman from the last clip was tested for levels the second time, which I don't really understand how that works either. Because wouldn't the first test show how much is in? Or are there different types of tests? I don't know. I have so many questions over that last defendant. I don't know. Hey, Nat. Good to see you. I don't remember this break being this long, sorry, but it's a good time to catch up with chat. And yes, for everyone that said it, Judge DiSanto does need a new chair. I don't know if is that her chair that was squeaking earlier? Because that was really bad.
It is. I apologize. I was looking at the wrong. So yes, you're right.
Back up, Bailiff.
That is the case number, and I do understand.
Okay. And so
Scheduled for 1:30.
it sure was scheduled for 1:30.
I've been here checking.
And the court will also note that Ms. Hoffman was ordered to test on October 31st, but did not even show up to test until November 2nd. So that's also the violation.
Yes. That was also.
Yes. So, and obviously in the other violations, that's a positive for methamphetamine.
That's correct.
And amphetamine, but I don't recall if she had a prescription for that. But in any event, she's not here. She's ordered to be here. It's 3:40, and therefore a warrant's going to issue.
I did notify her of these proceedings when we last left the court. Also, Your Honor, I also called her today, left a message on her answering machine, and I also texted her that she was being in court at 1:30. I have not heard a response from so I have no reason as to why she.
All right, the court's going to note that based upon Ms. Hoffman's previous failure to appear and leaving on her own without any communication with any court staff or approval, the court's going to order $10,000, 10% bond warrant issue immediately.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. I will see you on.
All right, sorry guys. That got really loud at the end. I need to do a better job of volume control. When it's too low, I turn it up, but when it's too high, I don't usually turn it down. I'm deaf, so it all comes through the same to me. But when I have my headphones in, it really sounds really loud. So I apologize for the end of that getting really loud. Also, thank you everyone in chat for the information on the drug testing. I've only taken one drug test in my life, and it was to get my first professional job about 15 years ago. And that's the only time I've ever had to do one. So I don't know how they work, only from what I've heard. But yeah, I just thought that was weird that that woman she tested twice and then was ordered again to test. But I will give you one small story. The Judge DiSanto did say she looked under the influence, and and the defendant said that she had taken Clozapine, that she's prescribed that. I've taken that once in my life. My sister gave me one. I know that's illegal. Turn me in. It was about 5 years ago. So, go ahead, turn me in. But that is the reason why I haven't taken a pill since. Ibuprofen about once every year. I don't take pills anymore because of that. That messed me up so bad for about 3 days. I can't do it. I don't know how people can take any type of pill and function. And like I said, it has me scared to take even ibuprofen now, because I felt funny for 3 days and it wasn't a good feeling. So I understand why she might have been like, waving back and forth while she was standing still. I don't know. But we're still talking about a case that was 2 clips ago. We didn't even talk about the last case. Yeah. Heidi's in some trouble. All right, we're going to finish it up with McConico. We got some bad people. And I love watching the prosecutor, Vincent, and what is it usually? It's Bird and I can't think of the other guy's name, that they usually go back and forth, and I enjoy it. So if you guys watch McConico every day, like it's not fun because we're dealing with people's lives, but it's a good back and forth between these 2 attorneys. It always is. So we're gonna finish with this. I got 2 clips from him, and then we're gonna call today. I will do another live tonight because this video was supposed to be last night, and now it's today, and now I'm rambling on and on. So let's just go watch it. Let's go.
306010401, people of the state of Michigan versus Martell Tafel McBride. Defendant charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm, less than murder or by strangulation. It skips the count weapons, dangerous weapons, carrying with unlawful intent. Count 5, weapons carrying concealed. Count 6, weapons, firearm possession by a felon. Also count 7, no. Count 7 is weapons, ammunition, possession by a felon. Count 8, assault with a dangerous weapon, felonious assault. Count 9, 10, 11, 12, 13, and 14, weapons, felony, firearm. Defendants labeled as habitual offender, third offense notice. Today is the day and time for a bond redetermination hearing.
Good morning, Judge Steve Benson for the people.
Your Honor, breaking on behalf of Martell McBride.
What's Mr. McBride's bond?
200,000 cash.
Argument.
The House of Records. He's 36, has priors. He does have, a previous FA. He's currently judged on probation, is my understanding. Right now, Your Honor. Now, obviously, Judge, the allegations are very serious. And we know that.
I'm sorry, Mr. Raven, before you go. Mr. McBride, state your name for the record.
Oh, okay. Let me get him unmuted. There we go.
Can you see me?
No, they can.
Can you see me?
We can always see you. Just state your name. Okay, I got you. All right, continue, Mr. Raven.
Oh, Judge. Well, so, he's on probation, Judge, like I said, for FA now, and we understand that the allegations are serious, Judge. We're not going to sugarcoat this in any way, shape, or form. Now, what I'm asking for, Judge, is I'm not asking for a person. I'm asking for some type of reduction. I think 200,000 is excessive. He's lives in the city. He's has for his entire life, Judge. He has 6 children that he supports. He makes a living, Judge, works at Magnum. I'm asking that the court allow him to at least keep his job for the sake of the kids. He can be on a tether. He can be on house arrest other than to go to work and come home. If the court allows him, if the court would consider a reduction in bond to something more reasonable. I mean, I understand 200,000 he can't afford. And I understand his charges are serious. But there's always more than one side of the story. And there's I think, a lot of moving parts to this situation, Judge, with both sides. But I just want the court to consider the reduction. I think that it's important, that you could, because we are innocent until proven guilty. So that's important that we look at it from that aspect as well. But I think protection of the community is important based on the fact that that's the court, that's the job the court has. So I'm asking for the tether and the house arrest only to he be allowed to go to work, Judge. That is what I'm asking.
All right, before we go too much further into this, for everyone that's making fun of me for self-snitching, yeah, it was, like I said, it was illegal. It was prescribed to my sister. Speaking of subscribed, if you haven't already, why not? I'm only like 10 away from 7,000. But it was right after my divorce, and I moved in with my sister. And I wasn't sleeping because I was missing my kids, and it was a hard time. And my sister was an MA, and she's like, "I take this. Why don't you try one?" That's how it went down. I'm not a pill junkie. I don't do that. But I trusted my sister, and I haven't trusted her since. Just wanted to clarify that. Heineken, how are you doing, bud? Thanks for stopping by.
I have to say, I have no idea. I don't even understand this situation. I don't get it. I don't understand. I don't understand what the complaint. I don't understand.
They went back with the gun, Judge. The complaint had a gun. I mean, it's my
right. Because allegedly she heard him telling another female, bring a gun and to come whoop ass. And so that's why when people have CPLs, when they hear threats of that's why they have a CPL but I mean, I don't get it. I just don't get it. And I don't get it. And because I don't get it, because this is senseless, because if this is triggering premeditation, plan, scheme, all the stuff we learn in criminal law. I mean, it's all there. This mens rea is pretty deep. For what? Taking too long with a clerk?
It's one side, Judge. One side.
It is one side, but I would really love to hear the other side. I'd really love to hear the other side because
I wish we could tell it to you right now.
I know, but all I got right now is that side, and it sounds real dangerous, real scary that people make decisions like that, and I have to protect the community against that type of decision making. And I think the magistrate was doing so also. So the bond continues.
So, Judge, and I do understand your position, Judge. I do.
Yeah.
But again, like the court says, you don't understand. It just makes no sense. A lot of times when they write it up, Judge, they write it so you will say exactly what you said. You don't get any perspective of the defendant because, he has absolutely a constitutional right to remain silent. But you get all of this novel from the one side. They lay it out so thick, but it's not always what actually happens, Ron. And you know this, Judge, because you've been doing this a long time.
But with this, I see a clear dangerousness, and that's why the unaffordable bond is appropriate.
Thank you.
So the bond continues. Thank you.
All right. Any try? I'm sorry, Your Honor. Yes, sir.
Whose case?
All right, I think we're going to the last one. I believe I only did 2 McConico hearings in this video, but it still shows like 15 minutes left. So this might be a longer one, or maybe I have 2 more. I don't know. Crash, if your name is Jeff, I did receive your PayPal. I was just about to say thank you, Jeff, for the donation. I very much appreciate it. If anyone else would like a shout out, the link tree is down below. But Crash, thank you very much if that was you. If it wasn't, I have not received it. So hopefully that was you. All right. I'm gonna there's still 15 minutes left. I gotta pause it once more. 15 minutes is too long. All right, let's watch the last one.
Yes, sir.
One more
Yes,
time.
sir.
Can you call the next case? Okay, I'm done. I'm done.
All right, anytime, could you unmute? I believe this is Walker, Madam Court Reporter. Madam Court, I would like to say, Annex High, I need you to unmute, please, so I can see if that's Clifton Walker. Also on the 8th floor of Wayne County Jail, what's your name, sir?
Jerome Williams.
Okay, thank you. And then at Annex High, what's your name?
Clifton Walker.
Okay. Clifton Walker, 3 cases. Calling case 23060068001, people of the state of Michigan versus Clifton Bernard Walker, defendant charged with count 1, assault with dangerous weapon, felonious assault, count 2, domestic violence, second offense notice. Also calling case 23060069001, people of the state of Michigan versus Clifton Bernard Walker, defendant is charged with count 1, assault with dangerous weapon, felonious assault, also count 2, count 3, domestic violence, second offense notice. Defendant labeled as habitual offender, fourth offense notice. Also case 230600701, people of the state of Michigan versus Clifton Bernard Walker, defendant is charged with count 1, assault with dangerous weapon, felonious assault, count 2, domestic violence, second offense notice. Defendant labeled as habitual offender, fourth offense notice. Today is the date and time for a bond redetermination hearing.
Good morning, Judge. For all 3 cases, Steve Vincent for the people, please 71917.
Judge, and may it please the court, breaking on behalf of Clifton Walker for all 3 cases, Your Honor.
Okay. Who's Clifton Walker? Clifton Walker, state your name.
Yes, I'm here.
Okay. 1 second.
Your Honor.
Yeah.
Actually, Your Honor, the wrong person lit up when he said it, so.
Who's Clifton Walker? Raise your hand, Clifton Walker.
I'm here.
Okay. All right.
See me, Judge?
I got you. Thank you, Mr. Walker.
Okay.
Hold on 1 second. Okay. Okay.
Hey.
All right, Mr. Reagan. Mr. Reagan.
Yeah, I'm sorry, Your Honor. My camera froze for a second. Judge, we have 3 cases for Mr. Walker. I think this bond is 150,000 cash each case. You know, we gotta really do better, Judge. I'm gonna talk to Mr. Walker. Now, we have a case on October 7th, allegedly, with Ms. Hayes, right? Then we have another case on October 13th with the same complaint, Ms. Hayes. Then we have another case on November 13th with Ms. Hayes. So I don't know if it's Ms. Hayes or if it's Mr. Walker. I'm trying to figure out because, if I have a case one time, I'm not coming back. Not the second time, not the third time. But it's my understanding that when the police arrested Mr. Walker, they made Ms. Hayes leave because she was in there smoking crack. That's what the information that I have. So I don't know if the dynamic of the relationship has Ms. Hayes keep coming back, but Mr. Walker, we got to do better. We can't have contact with Ms. Hayes. It's not working out. It's just really not, Judge. So I'm asking the court, and Ms. Hayes, we can't put no contact order on her because she's not the defendant. She's a complainant. But I'm saying to Mr. Walker, no contact. She does not live with him, so there's no reason. Keep the door closed. She can't smoke, can't come over, stay away. I do understand there's a pass for Mr. Walker. He's 63. He gets SSI monthly, gets a monthly check. But I don't know if Miss Hayes is going to show up to the exam. I don't know what's going to happen. I just know that this is a toxic situation, and they just need to stay away from each other. That's just what it is. That's what it is. So I'm asking the court to consider reduction. That's what I do. I'm asking for the reduction, and obviously, GPS tether if the court sees fit. This is going to go to Judge King next week, Judge, for PCC. But this is where we are, Your Honor. I just want to be honest with you. And this is what we're dealing with.
Okay. Mr. Prosecutor.
Judge, respectfully, I don't know whether or not you remember this defendant. He came before you last week on another matter. He had a $50,000 cash bond. You gave him the benefit of the doubt. You reduced it to $50,000, 10%. In that particular matter, so I refreshed my recollection so I could speak to you intelligently about that. That was an argument over infidelity where the defendant allegedly said, and I want to get this right, while he was attacking this same complainant with the screwdriver, I'm going to stab you, you're going to die. And then a few days later, within the same incident report, the complainant had to call the police because she locked herself in the bathroom because the defendant said he was going to kill her. And then I had also brought up, Judge, the fact that we had the same complaining witness from a 2022 DV case that's still ongoing because the defendant failed to appear multiple times for hearings in that case. And oh, by the way, he ended up picking up that case, not the charges. He picked up that case while he was on probation for a DV out of Macomb. Yep. And now we have 3 more cases. And I was thinking about this. He's like a one-man mob. He's like Steady Mobbin all on his own. He ends up picking up 3 more cases regarding this complaining witness, sending her to the hospital as a direct result of injuries that she's sustaining, and then 2 more subsequent cases where there are threats to kill. He's a one-man mob. He's mobbing. And Judge, you know what? The $150,000 I think is appropriate on all 3 of these. I think you gave him the benefit of the doubt with the $5,000 when he had a $50,000 cash. And Judge, let me just remind the court, this is one of the most impressive HAB notices I've ever seen, ever. Single space, almost the length of the page with priors. So, Your Honor, we do feel as though this defendant is a danger, at the very least, to the complaining witness. We would ask you to keep all 3 of those cash bonds.
Judge, I just want to be clear because this allegedly happened on November 13th. Now, when the court reduced Mr. Walker's bond, I just want to make sure we have the right Clifton Walker. It was reduced to $5,000 cash. Now, I know that Mr. Walker, did he pay $5,000 to get out? Or I'm trying to see the timeline. You said he was here, Brother Prosecutor, last week or the week before, or?
Yeah, Mr. Reagan, I think you're mistaken. He was charged with the November 13th, and he was arraigned on that prior to these charges. These charges were under review, and he ended up getting subsequently arraigned on these because I have offense dates of September 11th, October 7th, and October 11th that are before this court now.
I know, but that's what I'm saying. The ones I have are November 13th. So these are the wrong dates. So October 7th, October 13th, and November 13th are not the correct dates.
No, I have I have October 11th with an
Right.
entry date of 11/21. I have September 11th with an entry date of 11/21, and then I have a offense date of October 7th with an entry
Gotcha.
date of 11/21.
Gotcha. Okay.
October was the month of this stuff, and I don't know.
Gotcha.
Well, let me say this. The court finds that $450,000 worth of bonds are excessive. Now, that's a bit much. Now that's more than we are. That's more than for people who have actually shot folks and things that we've had today. So we're gonna start there. So the bonds are excessive. However, Mr. Walker has to have a cash bond. If Mr. Walker doesn't get a cash bond, there's no need for having a system of a cash bond. Mr. Walker is a danger to the community. He's a danger to the complaining witness. And so we got a lot going on here. We got crack smoking, we got infidelity, allegations, knives, beatings, phone calls, and it keeps happening. Now, I mean, Mr. Reagan was talking about it. I don't care how, I don't care what the passion is, what the love is. It's too much. It's too much contact with me. Okay, I don't want to keep dealing with this. So let the crack, the other drugs, the alcohol, the abuse, all of this is it just has to end. So Mr. Walker, I wish you luck. I wish you luck with getting these cases all wrapped up. The first bond I'm going to reduce to $150,000 personal. Second bond I'm going to reduce to $150,000 personal. The last bond we're going to reduce that one to $10,000 cash with house arrest, and we can have the exceptions for medical and court appearances only.
Thank you, Honor.
Thank you.
All right.
Good luck,
all right.
Mr. Walker.
Thank you.
All right. And that's all I got. That was my video from last night. Sorry, I took the night. Had to take a personal night. So that was my video from last night. I do have another video for tonight. Hopefully we get some good action this afternoon and I can put up some new stuff. Otherwise, it's mostly going to be stuff from yesterday. There wasn't a ton of good stuff this morning, but I did get some stuff yesterday. So look forward to it tonight. I'm not sure what time yet. It's probably going to be an early one between 5 and 5:30 p.m. It's kind of the sweet spot I like to do it. If not that time, it's going to be probably between 8 and 8:30. So there's the window. But I will be going live again tonight. Thank you all for showing up. As always, I appreciate it. If you haven't done it already, buttons right underneath the video. Like the little thumbs up button, that's great. The subscribe button, that's great. Hey, I'm almost at 7,000 subs. So tonight we could have the 7,000 sub party. That would be fun, right? So let's work on that. Let's work on that. All right. I guess that's it. Until next time. Bye.